Imagine logging into a government app on your phone, just to check a routine update on your work authorization.
Right, something people do every day.
Exactly. But this time, you log in and find that your legal right to reside in the country has just been, well, digitally deleted.
Gone.
Gone. There is no physical letter in the mail. There's no scheduled court hearing to contest it. Just a sudden, silent update in a portal.
And the terrifying part is that this isn't a glitch.
No, it's not. For many individuals relying on U.S. sponsorship pathways right now across 2025 and 2026, that is just the new administrative reality.
Yeah, we are looking at a really fundamental restructuring of how the federal government manages immigration and sponsorship.
Which is exactly why we're here. Welcome to the Deep Dive.
Glad to be here.
Over the past year or so, the policy landscape for U.S. sponsorship has just undergone this massive systemic overhaul. So our mission today, for you listening, is to cut through all the noise.
Because there is a lot of noise out there right now.
So much noise. And we're keeping the politics out of it. We have compiled the latest policy updates, legal advisories, legislative texts, all of it, just to extract the practical realities. We want to look at exactly what is happening, who is affected, and most importantly, the actionable steps that sponsors and newcomers need to take right now.
Yeah, because if we connect this to the bigger picture, understanding the logic behind these policy shifts is really the only way to adapt.
Right.
The government's stated rationale for a lot of these changes revolves around, reducing systemic backlog, reallocating federal resources, and addressing budget deficits.
It's a numbers game for them.
Exactly. But while the downstream effects on individuals are just profound, breaking down the administrative plumbing, like how these new rules actually operate day to day, that is how you regain a sense of operational control.
Okay, let's unpack this. We have 4 major policy areas to cover today.
Big ones.
Yeah, really big ones. We're looking at the complete termination of the Welcome Corps program, the digital termination notices targeting the CHNV parole program, the really complex bureaucratic freeze on Uniting for Ukraine, which people usually call U4U, and finally the severe healthcare restrictions under H.R. 1.
It's a lot of ground to cover.
It is. So let's just start with the most definitive closure, which is Welcome Corps. In late February 2025, the State Department completely terminated this initiative.
Terminated, not paused.
Right. Complete hard stop. There is no phase-out period. No new applications are being accepted. But I think the most critical and honestly devastating detail for sponsors is that pending applications will not be processed at all.
Yeah, they won't even be certified.
Yeah.
The underlying logic here is entirely about infrastructure.
What do you mean by that?
Well, the apparatus required to, vet and process and certify private sponsorship groups under Welcome Corps, it was highly resource intensive.
Right, lots of personnel needed for that.
Exactly. So policymakers opted to just dismantle that specific processing infrastructure entirely. If you have an application sitting in the queue right now, it isn't just paused. The office that was supposed to review it essentially no longer exists in its previous capacity.
It's like showing up for a flight you booked and paid for months ago, only to find the entire airline has been liquidated overnight.
That is exactly what it feels like.
But wait, I have to ask, for people who had applications pending, people who spent months organizing funds and doing background checks, is there any appeal process? Or do those applications just vanish into the ether?
They vanish.
Seriously?
Yeah, there is no appeal process because there's no one to appeal to. The infrastructure is gone. Sponsors really need to understand this finality so they don't waste time waiting for a pipeline that's been dismantled.
They need to pivot.
Right, they have to pivot to alternative legal pathways immediately.
Okay, so that's a hard shutdown and intake. But let's move to something that's arguably even more stressful, which is the active revocation of existing status.
Right, the CHNV program.
Yes, CHNV. So this covers individuals from Cuba, Haiti, Nicaragua, and Venezuela. And as of June 12, 2025, the Department of Homeland Security shifted from processing arrivals to issuing direct termination notices for humanitarian parole status and work authorization.
And we really need to talk about how they are doing this because the delivery method is just as important as the policy itself.
The digital aspect.
Exactly. DHS is utilizing highly targeted digital enforcement. These termination notices are being sent directly to individuals' My U.S. ACIS accounts.
So no letter in the mail.
No. The federal government is moving away from physical mail for these critical updates. It's likely for, efficiency and immediate tracking.
Which means if you aren't checking your phone.
You're in the dark. If a newcomer is relying on the CHNV program, checking that digital portal daily is no longer optional. It is absolutely mandatory.
Okay, so say you check the portal and the termination notice is there.
Oh.
The guidance universally recommends that anyone impacted by this needs to secure an immigration attorney immediately. But I really need to push back on the feasibility of this for a second.
Sure.
We are talking about thousands of recently arrived people whose right to work is literally being revoked. How are they realistically supposed to afford private immigration attorneys?
It's an incredibly valid friction point and honestly a huge crisis. The reality is that pro bono networks and legal aid clinics, they are entirely saturated right now.
I can imagine they must be drowning.
They are, but the guidance advises securing counsel anyway because navigating an active termination requires filing very specific defensive applications.
Which you can't just do on your own.
No, they are almost impossible to manage without legal expertise. For a lot of families, pooling resources just to afford a 1-hour initial consultation might be the only viable step to at least understand their specific timeline.
Just to get a roadmap.
Exactly. Operating without any legal blueprint is simply too high a risk when your status is actively being revoked.
Right. And let's talk about a very specific tool that legal counsel provides, because all the sources emphasize this one document heavily. Form G28.
Yes, the G28.
Officially, it's the Notice of Entry of Appearance as attorney or accredited representative. My understanding is that carrying a physically signed copy of this form is crucial, especially in the event of an encounter with ICE.
It is absolute necessity.
Can you explain to the listener why carrying this specific piece of paper is so important?
Yeah, so Form G28 is essentially a legal shield in an administrative state. If an individual encounters an ICE officer out in the world, verbal claims mean very little.
Right, you can't just say, I have a lawyer.
Exactly, they hear that all day. But producing a physically signed Form G28 changes the entire procedural dynamic. It legally binds the authorities to communicate with your legal representative.
It forces their hand.
It does. It invokes a specific set of operational procedures that law enforcement must follow. Every single newcomer in this situation needs to carry that physical paper in their wallet at all times.
Okay, so we've seen the hard stops with Welcome Corps and these active digital terminations with CHNV. Let's pivot to Ukrainian newcomers under the U4U program, because this operates on a completely different mechanical level.
It's a totally different beast.
It's like a state of suspended animation. On January 28, 2025, the government paused the U4U program.
Right.
No new applications, pending cases frozen, and crucially, no new travel authorizations issued for those outside the country.
The rationale they provided for this pause was that they needed to reevaluate the scope of parole authority and, just manage the sheer volume of cases that are accumulated.
The backlog.
Yeah, but the immediate effect was this massive geographic divide. Individuals outside the U.S. were completely blocked from entering under the program.
Here's where it gets really interesting. It's basically a drawbridge situation. The bridge has been pulled up for anyone trying to cross from the outside, but if you're already inside the castle walls, the rules are suddenly different.
That is a perfect analogy, because in August 2025, USCIS subtly shifted the policy. They resumed processing U4U renewal applications, which is technically called reparole, but strictly for Ukrainians who had already arrived in the U.S. before the pause.
So they just moved the bottleneck.
Exactly.
Yeah.
The system just shifted the delay from intake to renewals. So USCIS is accepting these reparole applications for those inside, but the processing times are severely backlogged.
So people are just stuck.
Yeah, you have individuals sitting in a digital queue for months. Their previous status is expiring. They can't legally work. They can't renew driver's licenses.
Wow, even driver's licenses.
Oh, yeah. They are entirely stuck while they wait for the bureaucracy to catch up.
But you don't just have to wait helplessly in a digital queue. The sources outline a very specific action a sponsor can take. They recommend contacting your congressional representative staff to file a constituency request.
This is a really powerful tool.
Explain the actual mechanics of this. Why does a local congressional staffer have any influence over a massive federal agency like USCIS?
It comes down to statutory obligations. Federal agencies have dedicated congressional liaison offices.
Okay.
So, when a constituent contacts their representative's office to report a severe processing delay, especially one that's impacting employment or, basic stability, the congressional staff can file an official inquiry.
And USCIS actually has to respond.
Yes, USCIS liaisons are generally required to pull that specific file, manually review its status, and provide a direct update to the congressional office within a specific time frame.
Oh, wow. So it forces a human being to look at the file instead of an algorithm.
Precisely. It circumvents that standard public queue. Now, it doesn't guarantee that the reparole will be approved, but it effectively unsticks the application from the backlog and forces an active review.
That's huge.
It is. For sponsors feeling helpless, leveraging their elected officials' casework team is one of the few active levers they can actually pull right now.
Okay, let's pivot the lens completely.
Yeah.
Because everything we have discussed so far, Welcome Core, CHNV, U4U,
Yeah.
that all centers on legal residency, right? The right to exist within the
But
board.
paperwork.
Right, the paperwork. But having the legal right to remain is only half the battle. Day-to-day survival requires access to basic infrastructure.
Absolutely.
And this brings us to the massive, sweeping healthcare shifts introduced by H.R. 1.
This is where things get incredibly difficult on a daily basis.
The legislative logic here, according to policymakers, was to significantly reduce federal deficits by restricting state-subsidized healthcare access for non-permanent residents.
Yeah, H.R. 1 fundamentally rewrites eligibility for the American healthcare safety net. The law places strict limitations on who can purchase health insurance through the Affordable Care Act, the ACA marketplace.
Which is how a lot of people get their insurance.
Exactly. And it also slashes the federal tax credits that traditionally lower monthly insurance premiums for lower-income individuals.
Wait, let me make sure I'm hearing this right, because the list of excluded groups seems massive.
It is.
If I'm a resettled refugee, or an asylee who just hasn't received a green card yet, or a TPS holder, or an asylum applicant, I am completely locked out of Medicaid, Medicare, CHIP, and the ACA marketplace.
Entirely locked out. The objective was to prioritize federal healthcare subsidies strictly for citizens and permanent residents.
So what happens to everyone else?
The downstream effect is that hundreds of thousands of legally authorized newcomers are now pushed entirely into the private, out-of-pocket medical market.
Which is incredibly expensive.
It's cripplingly expensive. But what's fascinating here is the hyper-specific nature of the carve-outs written into this law.
There are exceptions.
Yes. While almost all newcomer categories are excluded, H.R. 1 explicitly maintains eligibility for 3 groups: green card holders, specific Pacific Island communities, and notably Cubans and Haitians who entered the U.S. through humanitarian parole.
Okay, hold on. Let's look at the massive contradiction here.
I know where you're going with this.
Right. H.R. 1, a legislative bill passed by Congress, specifically protects healthcare access for Cuban and Haitian parolees.
Correct.
But earlier, we literally just discussed that DHS, an executive agency, is actively sending termination notices to revoke the parole status of that exact same group under the CHNV program. How does a hospital billing department even begin to process someone who is legally protected by Congress, but actively being terminated by the executive branch?
You have just highlighted the massive collision between administrative law and legislative action.
It sounds like a nightmare.
It is. Congress operates on long, multi-year drafting cycles. When H.R. 1 was written, Cuban and Haitian parolees were a recognized group they actively chose to exempt from the cuts.
But DHS moves faster.
Way faster. Executive agencies like DHS can issue memos and update digital portals to change policy almost overnight. The two branches of government are operating on completely different timelines, and it's creating severe friction points on the ground.
Because a hospital administrator literally has to look at a patient and figure out if their legislative carve-out overrides their digital termination notice.
Exactly. And this raises an important question about the strategic value of a green card in this new landscape.
And so?
Previously, obtaining permanent residency was viewed as this sort of long-term goal for stability and eventually citizenship.
Sure, the American dream.
Right. But under H.R. 1, securing a green card is an immediate, day-to-day survival necessity, simply to be allowed to see a doctor or purchase health insurance without going bankrupt.
The pressure is just immense.
The pressure to expedite alternative legal status has multiplied exponentially.
So, what does this all mean? We have covered some dense, heavy administrative territory today. Let's try to synthesize the ultimate survival toolkit for sponsors and newcomers navigating 2026.
Let's do it.
First, The method of government communication has changed. If you are a newcomer on a parole program, checking your MyUSCIS portal is a daily requirement. The termination notices are digital, they are not physical.
Check it every single day.
Second, the complexity of these active terminations means securing an immigration attorney is critical, and carrying a physically signed Form G-28 is your legal proof of representation during any encounter with ICE. Keep it in your wallet.
Absolutely. And third, you have to understand the mechanisms of the bureaucracy. If you are dealing with the U4U re-parole backlog, don't just wait. Utilize your congressional representative's casework team to force a manual review of the application.
Make them look at your file.
Yes. And finally, understand your severe healthcare limitations under H.R. 1. Unless you hold a green card or fall into one of those very specific legislative exceptions, access to the federal health safety net is effectively closed.
Which fundamentally changes how you have to plan for any kind of medical emergency.
It really does. I just want to add, while this landscape is intensely restrictive and frankly overwhelming, understanding the exact parameters of these rules is your ultimate armor.
That's a great way to put it. Navigating the system requires moving away from assumptions and dealing strictly with the mechanical realities of the policy.
Knowing the rules is the only way to survive them.
Exactly. Now, before we wrap up today, I want to leave you, the listener, with a thought to consider regarding the broader societal impact of all these shifts.
It's a big question.
With federal pathways like Welcome Corps fully dismantled, parole programs facing targeted digital terminations, and H.R. 1 effectively locking newcomers out of the federal healthcare infrastructure, how will local grassroots community networks have to evolve?
Right.
If the federal safety net is removed by legislative design, will we see the rise of entirely new, decentralized support systems to fill that void?
Right.
Are we looking at a future of community-funded medical pools and off-the-books neighborhood support networks stepping in where federal policy has stepped back?
It's very possible.
It is a profound shift in where the burden of sponsorship and support ultimately rests. Something to really think about. Thanks for diving deep with us.